podcast and webcast. I'm going to have to cross out about half my speech now. Always pleased to come to the Future of Music conferences. I think the Copyright Office has participated with you folks since the beginning in 2001, and we always enjoy coming here, in part because the audience is at least a little different. I'm used to speaking mostly to copyright lawyers, and looking out here I see there are plenty of copyright lawyers, but there are at least a handful of musicians here, the people who we're supposedly supposed to care about, and it's nice to have some of them in the room. You also picked a good time for this conference, although you couldn't probably have known how good it was, just because of recent developments with copyright and music. We heard this morning about the recent webcasting rate ruling, which was officially published only yesterday. Just last week, a federal court in New York issued a significant ruling addressing public performance rights and the downloading of music. Last fall, we at the Copyright Office issued a ruling on ringtones that got the attention of a lot of people. And more generally, music licensing reform is an issue that is perennially on Congress's agenda and presumably will be on Congress's agenda this year. We've certainly had a lot to say on that, and I'll say a lot on that in the next few minutes. Oh, thank you. I'm going to talk about all these developments, and if time permits, I may also address orphan works, the one item of copyright legislation that most observers say has a decent chance of getting enacted this Congress. If I don't get to that, maybe you can ask Jewel Sigel, who will be on the next panel, who is probably the father of orphan works. Although I realize being the father of orphan works makes you dead, so maybe that's not a good appellation. But let's start with a webcasting rate determination, since there's been so much discussion about it already. From our point of view at the Copyright Office, in the immortal words of Yogi Berra, it's deja vu all over again. I'm pleased to say that we at the Copyright Office can deny any responsibility for this decision. I'm pleased not because it necessarily was a bad decision. I have absolutely no views on whether it was the right or wrong decision. But I'm just glad because it's nice not to be the target of all those complaints, and because, frankly, we were relieved when Congress took us out of the rate-setting business a couple of years ago and gave that job to somebody else. 5 years ago, in 2002, we at the Copyright Office had to cope with the issue of webcasting rates. At that time, we had a different system, the Copyright Arbitration Royalty Panels, or CARPs, and the CARP at that time recommended a fee of 7/100th of a cent per performance for simulcasters and 14/100ths of a cent per performance for Internet-only webcasters. Under the law at the time, the CARP's determination then came to the Register of Copyrights, who had to review it and make a recommendation to the Librarian of Congress whether to accept it or to reject it and come up with new rates. We ended up accepting much of the CARP's determination, but rejecting the decision to charge Internet-only webcasters twice the royalties charged for simulcasters, so everyone had to pay 7/100ths of a cent per performance. The reaction to that? Well, Kurt Hansen's Radio Internet newsletter predicted that, among other things, many webcasters and broadcasters will abandon webcasting altogether, and many webcasters and some broadcasters will declare bankruptcy because of the nature of the proposed fees. Congressman Inslee at the time complained that the rate will lead to elimination of hundreds of small businesses and that he was considering introducing legislation to change the standard used in setting royalties from willing buyer, willing seller to the traditional formula used for other statutory licenses. And Congress did step in a couple of ways. Later that year, it enacted the Small Webcasters Settlement Act, which permitted smaller webcasters to negotiate lower rates on a temporary basis. But Congress made clear that those lower rates would have no precedential value and couldn't even be considered in future proceedings. More fundamentally, the 2002 webcasting rate determination was almost certainly the primary reason that 2 years later, Congress got rid of the CARP system and came up with a new entity that would make rate determinations for the statutory licenses, the Copyright Royalty Judges, or CRJs. So Congress's solution to the dissatisfaction with the webcasting rates set in 2002 was to come up with a new system, a new entity to make those determinations. Rather than have ad hoc panels of arbitrators that changed with each rate determination and built up no expertise in setting copyright royalty rates, Congress decided to have a permanent body consisting of a chief copyright judge with at least 5 years of experience in adjudication, a copyright judge with a significant knowledge of copyright law, and a copyright royalty judge with significant knowledge of economics. And who ended up as the copyright royalty judges? Well, a former federal bankruptcy judge, someone who presumably can understand arguments made by webcasters who claim that the royalties are going to bankrupt them. Second, a longtime attorney at the Copyright Office who specialized in the statutory licenses for years. And finally, a PhD in economics with extensive experience as an arbitrator, also a lawyer. Sounds like a pretty qualified group. The Copyright Royalty and Distribution Reform Act also made other changes for the benefit of webcasters. For example, webcasters were among the primary proponents of liberalizing discovery in rate adjustment proceedings. We warned about the potential for abuse of discovery and the potentially high cost of discovery, but webcasters got what they asked for, and you heard something about that this morning. So, largely in response to the complaints of webcasters who were unhappy with the 2002 webcasting rate decision, Congress came up with a new system for setting rates. And this year's webcasting rate determination was in fact the first ruling from the new copyright royalty judges. What was the reaction? Kurt Hansen's Radio and Internet newsletter reports predictions that, among other things, many webcasters and broadcasters will abandon webcasting altogether, and many webcasters and some broadcasters will declare bankruptcy because of the nature of royalty fees. And Congressman Inslee recently introduced legislation that would replace the rates set by the copyright royalty judges with dramatically lower rates and would change the standard from willing buyer to willing buyer, willing seller to the four-factor standard in Section 801 that's used for some of the other statutory licenses. So like I said, for us it's déjà vu all over again. I'm not going to express a view on whether the CRJ's got it right, although from what I've read, even some of the more vociferous critics of their decision acknowledge that given the current willing buyer, willing seller standard, it's not clear that they reached the wrong result. Many of the complaints are about the standard that is in fact written into the law. And I don't have a definitive view on whether the standard should be changed to the four-factor standard used for some of the other statutory licenses. I think we do agree in principle that the same standard should be used across the board. The question is, what standard should it be? I will note that webcasters, through the Digital Media Association, have supported the proposed PERFORM Act, the Platform Equity and Remedies for Right Holders in Music Act, which would change the standard from willing buyer, willing seller for webcasting to the fair market value of the rights licensed under this section. Now, some folks have said that the four-factor standard is in fact the same thing as a fair market value standard. But when I read those four factors, they don't spell out market value or fair market value to me. And you don't really have to take my word for it. In 1999, when the RIAA complained that the first rates set for subscription services under the four-factor standard were too low because they didn't reflect market value, the U.S. Court of Appeals for the D.C. Circuit made it pretty clear that the reasonable compensation required by law under that four-factor test is not the same thing as fair market value. And in previous rate-setting proceedings, both the CARPS and the Register of Copyrights have stated that a fair market value rate is that which most closely approximates the rate that would be negotiated in a free market between a willing buyer and a willing seller. Now, we're inclined to think that royalties for statutory licenses probably should be set at fair market value. To us, that follows from the very rationale for having statutory licenses. In general, statutory licenses are not favored. We prefer to let authors and copyright owners exercise exclusive rights and decide under what conditions and for what price they will license the use of their works. But in certain exceptional cases where the market doesn't work well, for example, where broadcasters or webcasters would have to clear the rights of a vastly large number of works in order to operate their businesses, and where the transaction costs for clearing those rights would be absolutely prohibitive, Congress has enacted statutory licenses to simplify the licensing process. However, the need to enable the licensing of works by means of statutory licenses does not necessarily justify the setting of subsidized or artificially low royalty rates. If the purpose of the statutory licenses is to enable licensing in circumstances where it's difficult to negotiate those licenses in the marketplace, we nevertheless should try to replicate as much as possible the royalties that would have been arrived at if the license had been negotiated in the marketplace. Fair market value sounds like it may well be the right standard to us. And if that drives some webcasters out of business, it doesn't necessarily mean Congress should intervene. That's a policy judgment Congress has to decide on. We don't give webcasters a break on their utility rates or their rents. We don't give them exemptions from minimum wage laws. Why should we set copyright royalties artificially low just to enable users of copyrighted works to stay in business? In a fair market, those who can't make a profit because their costs exceed their income do go out of business. If the costs they have to pay for music are in fact the market rates, then it's fair to ask whether legislation should permit them to pay less. Legislation that would deny copyright owners and performers the true value of their use of their recordings and performances. Maybe such legislation would make sense. As I said, that's a policy issue for Congress, but it's at the very least a debatable proposition. Let me make clear that I'm not saying that the rates set by the copyright royalty judges are necessarily the right rates. The Court of Appeals will be reviewing that determination, and it's not for the Copyright Office to express any views on that question. When Congress took away our role in setting rates, we were quite happy to leave that issue behind us. But I certainly would not presume that the copyright royalty judges got it wrong. Congress established the qualifications for the copyright royalty judges with plenty of input from all the affected communities, including webcasters. I meant by those standards, the current copyright royalty judges are highly qualified. They made their determination on an extensive record after lengthy hearings applying the rules that Congress prescribed for them. And as we heard this morning, webcasters and copyright owners were represented by top-notch attorneys who apparently spared no expense in making their cases. There's a process for judicial review. It's in place, and the Court of Appeals will ultimately determine whether the copyright royalty judges got it right. Now, let me use that as an opportunity to launch briefly into a discussion of a related issue that was also discussed this morning, a full performance right for sound recordings. In 1995, for the first time, we finally recognized a limited performance right for sound recordings, but importantly, there was an exemption carved out for broadcasting. The Copyright Office has long supported a sound recording performance right, as well as elimination of the exemption enjoyed by broadcasters. For broadcasters of music, which is obviously a key segment of broadcasting, particularly radio broadcasting, people tune into the radio to hear the music. We simply don't understand why the broadcasters who make their livings off the music shouldn't have to pay the people who produce the music and make their livings off the music. To be sure, we are not really talking about a full performance right. A full performance right would mean that a copyright owner would have a right to tell you whether or not you can perform the work and at what price. As a practical matter, a performance right for sound recordings would have to consist of a statutory license. Broadcasters would be able to continue to play the recordings they like, but subject to paying a statutorily set royalty fee. We think there's sympathy for this idea in Congress. Enough is another question, but there's sympathy for sure. And we hope to see movement on that front in this Congress. Now here's an idea, and I emphasize it's just an idea. It's certainly not a Copyright Office proposal. Why don't Sound Exchange and the RIAA join forces with webcasters and Congressman Inslee and support Congressman Inslee's legislation, but with an amendment that extends the statutory license to broadcasters? Sure, RIAA and Sound Exchange will complain that the rate is too low, but does anyone doubt that the additional royalties, even at that lower rate, that come from broadcasters would dwarf what they get now from those folks who are within the license? Just a thought. Let's move on to music licensing reform, an issue that we in the Copyright Office have devoted a tremendous amount of time to over the past several years. But before I get you lost in all the minutiae of copyright compulsory licensing, let me make it clear what our message is on music licensing reform. First, it seems clear that the future of the music business lies in transmissions of music, whether on the internet or to cell phones or by some other means to some other devices. We all know that CD sales are in decline, and only the most hopeless optimist could imagine that they're not in a permanent state of decline. So musicians and songwriters and music publishers and record companies have to find a way to make their livings from this new market for digital transmissions. Anyone who relies on the old business models is not going to survive. That makes it crucial that we do everything we can to get it right, to make it easy for online music services and others who are in the business of selling transmissions of music to acquire and pay for the right to make those transmissions, and to make sure that the musicians and songwriters and record companies and music publishers get paid. It's regrettable, but it's probably a fact of life that in the 21st century, music has in many ways become a commodity. For those of us who grew up in the traditional copyright world, a world in which authors and copyright owners have the exclusive right to exploit their works and can decide whether and under what circumstances the works are used, it's a bit of a shock to find ourselves in a world in which consumers make demands that you have to satisfy if you want to survive. In an age when it's all too easy to get all the music you want for free, the music community has to figure out how it can compete with free. It's not enough to say that most of the ways to get music for free are illegal, because far too many people are willing to engage in illegal conduct in order to get all the music they want, when they want it, and without having to pay for it. What that means is that copyright owners have to give up some of the control they'd like to exercise over their music. And this really is nothing new in the music world. Since 1909, we've had a compulsory license that allows a record company to make a cover version of any song that's previously been released. That compulsory license is now found in Section 115, and as long as you comply with the requirements of Section 115, the most important one being to pay a royalty that's set by law, you're free to cut that record and to distribute it. Moreover, in 1995, Congress amended Section 115 to include DPDs, digital phonorecord deliveries, such as downloads, in the same compulsory license. But while that compulsory license may look good on paper, in reality it does not work very well, at least not in the online world. In particular, there are two key problems with Section 115 that prevent the efficient licensing of musical works by online music services. First, unlike statutory licensing for webcasting, which is a blanket license that allows a music service to get the right to stream all sound recordings simply by filing a single notice with the Copyright Office, Section 115 requires that a music service serve a notice on the copyright owner whenever it wants to offer DPDs of a particular song. Historically, that's been interpreted as requiring a separate notice for each song, and the notice has to be served on the copyright owner, if you can locate the copyright owner. If you're on iTunes, which sells downloads of millions of titles, that's just impossible. The second problem is that it's not always clear what rights you need to license in order to engage in downloading or in streaming, or with whom you have to clear those rights. The easiest way to understand the problem is to compare how you clear the rights to make a digital transmission of a sound recording of a musical work and how you clear the rights to the musical work itself. For the sound recording, it's relatively simple. Assuming you can identify the record company, you go to that record company and in a single transaction and for a single fee, you clear the distribution, reproduction, and performance rights for that recording. But for the rights to the musical work, assuming that you're engaging in both public performances and in reproduction and distribution, you have to go to two different places for each musical work. To license the public performance right, you go to a PRO, a Performing Rights Organization, ASCAP, BMI, or CSAC, depending on the song. And for the reproduction and distribution rights, you go to the music publisher. Or, for a majority, but by no means all of the songs, you may be able to go to the Harry Fox Agency. And here's the catch. If you're a download service, you'll be faced with demands from both the Performing Rights Organization and Harry Fox to get licenses from each of them. And if you're a streaming service, the same two agents for the very same copyright owners will show up at your door demanding payment. Now, in older, simpler times, it would have been unusual for both the PRO and Harry Fox to demand payment for what seems to be the same activity. But in the digital world, where all sorts of transmissions at least arguably involve both reproduction and public performance, at least on a technical level, online music services find themselves having to pay two different agents who ultimately represent the same copyright owner for what the music services perceive as being exactly the same activity. So even though a layperson might think that streaming is just a performance, a high-tech version of broadcasting, and that downloading is just a delivery of a copy, a high-tech version of buying a record at a record store, music publishers and PROs have plausible grounds to assert that streaming and downloading both involve a number of rights and that you have to get a number of licenses. Now, whether or not a number of rights are involved, keep in mind that it's much easier to clear those rights to the sound recording than it is to clear the rights to the music on the recording, because the record company controls all the rights and is willing to give you a single license that covers it all. But again, you have to go to two different places to get those rights for the musical work. There are good historical reasons, some of them based in antitrust law, why music licensing is divided into PROs for performance rights and music publishers for reproduction and distribution rights. But today that division seems artificial and at least is perceived as being unfair. and it's certainly an impediment to efficient licensing. We need to find a way to unify the licensing of all rights to a particular work so that they are licensed in a single transaction. In fact, what we really need to find a way is to unify the licensing of all rights to all works so that online music services don't have to engage in a separate transaction for each song they offer. The transaction costs of doing that are simply too high. So that's the overview on music licensing reform. I'll spare you most of the details I was going to give you on just because I just looked at my watch and I saw how much time I have. But I'll touch upon them a bit just to give you a sense of what we've been up to for the past 6 years in attempts to fix the problem. Futile attempts, I would have to say, thus far. To start with, there's an issue of what is a digital phonorecord delivery. I'm going to read you the statutory definition just to give you a sense of how mind-boggling it is. Each individual delivery of a phonorecord by digital transmission of a sound recording which results in a specifically identifiable reproduction by or for any transmission recipient of a phonorecord of that sound recording, regardless of whether the digital transmission is also a public performance of the sound recording or any non-dramatic work embodied therein. A DPD does not result from a real-time, non-interactive subscription transmission of a sound recording where no reproduction of the sound recording or musical work embodied therein is made from the inception of the transmission through to its receipt by the transmission recipient in order to make the sound recording audible. Lots of ink has been spilled on what this means. We're the folks who, at least in the first instance, are supposed to decide, do we have a clue? We probably have a clue. And if that weren't difficult enough, Section 115 also directs that the rates for the compulsory license for DPDs must, here's another quote, distinguish between digital phonorecord deliveries where the reproduction or distribution of a phonorecord is incidental to the transmission, which constitutes the DPD, and digital phonorecord deliveries in general. So you need to understand what a DPD is, and you need to understand what an incidental DPD is. In 2001, the RIAA petitioned us to clarify what those were, particularly in the context of on-demand streams and limited downloads, and to determine whether on-demand streams and limited downloads involve digital phonorecord deliveries and incidental digital phonorecord deliveries. I don't have the time to go into the details, but there are serious reasons to question whether an on-demand stream is within the scope of 115, whether it is a digital phonorecord delivery. There is no reason to doubt that on-demand streaming, or any streaming for that matter, involves reproductions and therefore implicates the reproduction right controlled by the music publisher. Reproductions are made. They're made on the server initially, and they're made in the course of the transmission at many points along the way, including usually at the recipient's end for a transitory period. The question is whether they fall within that definition of DPDs. Are they, in fact, specifically identifiable reproductions by or for a transmission recipient? Good question. And a question that needs to be resolved in order to determine whether on-demand streaming is, in fact, within the scope of the Section 115 license. With respect to limited downloads, I think the resolution is probably easier, but I'm not going to take the time to go into that. I'll mention also that in 2001, we came out with the report that we imagine will be called the DMCA Section 104 report, because Section 104 of the DMCA told us to do it. And one of the issues we examined there was temporary copies incidental to a licensed digital performance of a musical work, such as temporary buffer copies made in random access memory in the course of rendering a digital music stream. We concluded, as a matter of policy, that when one is engaging in a licensed act of streaming where the performance right has been licensed, notwithstanding the fact that reproductions are made in the course of streaming that music, there should be no liability as a matter of policy for the reproductions that are made. In other words, when you're engaged in a licensed performance and there are incidental reproductions made to facilitate that performance, those reproductions should not be subject to licensing. You should essentially be exempt. We also concluded that under existing law there are very strong arguments that those reproductions would fall within the scope of fair use. And just to be even-handed, and just to alienate everyone in the music world, we address the flip side, which is, what about downloads? Because there is an argument that has been pursued by performing rights organizations that for every download there is not only a reproduction, and a distribution, but also a public performance, which of course the PROs license. And there is a plausible technical reading of the law which would support the notion that whenever you download music, there is in fact a public performance. And that's what has justified PROs in demanding payments for those. Well, the good news is, at least from our point of view, it's good news, that last week Judge Connor in the Southern District of New York ruled that with respect to downloads, there is no public performance right. And the circumstances under which he made that ruling were a motion by ASCAP, which is subject to his jurisdiction as part of a decades-old consent decree which gives him supervision over their rate setting, where ASCAP rather audaciously asked him to rule that downloads do implicate public performances so that he could go to the next step and set a rate for public performances. Well, Judge Connor wasn't buying that, but before he issued his ruling, I actually thought this wasn't a very bad thing for ASCAP to do, because if he granted the motion, perhaps people would finally realize the absurdity of the position and realize they had to do something about it. But actually, on second thought, it's better that he actually made the right ruling, and we've at least now resolved that. Of course, it'll be appealed. The Second Circuit may see it differently, but there's some reason to hope that that issue of law, which is a matter of legal analysis, was arguably a close one, has been settled, at least in the first instance, by a court, and we think settled the right way. There have been attempts to determine how to reform music licensing over the last several years. At the direction of the chairman of the House Subcommittee on Intellectual Property back in 2004, we led discussions among music publishers, PROs, record companies, and online music services to attempt to figure out how to address many of these issues. Our model was Section 114, a blanket license, sound exchange form of model. We made some progress where, at least in principle, everyone was willing to pay serious attention to that notion, but ultimately, particularly when it got to the details, we reached no agreement. The next year, having despaired of reaching any agreement among the parties, we suggested to the chairman our own solution, and he held a hearing at which we explained our solution. Our solution was essentially based on the pretty successful model of the performing rights organizations. And we said, let's expand that model to MROs, music rights organizations, which would license all rights, not just performance rights, but also reproduction and distribution rights, so that you could have one-stop shopping. We still think that's probably the best solution, but music publishers didn't like it. Performing rights organizations didn't like it. Self-preservation is a very strong instinct. And politically it was dead on arrival. But perhaps one day people will see the light. Last year, digital music services and music publishers got together and worked out a compromise which Chairman Smith sponsored, something called the Section 115 Reform Act. It was a pretty decent attempt to address many of the issues. We had to bite our tongue with respect to some of its provisions, but at least it would have allowed for the efficient licensing of all necessary rights involved, reproduction rights involved in streaming, for example, which has always been a sticky issue. Online music services were willing to accept the notion that there might be an obligation to pay for those reproductions made in the course of streams in exchange for the certainty that they would have a mechanism to license them, and in the hope that they could persuade the copyright royalty judges to set a zero rate or a very low rate. But as time went on, the Section 115 Reform Act became loaded with more and more baggage, which ultimately weighed it down and got nowhere. The reading we're getting this year is that the people who supported it last year may not necessarily be supporting it this year. We're not seeing a whole lot of interest in Congress necessarily pushing it, which led to the hearing that the new chairman of the House Subcommittee, Chairman Berman, conducted several weeks ago, at which the sole witness was my boss, the Register of Copyrights, Mary Beth Peters. And at that point, I have to say, at this time we've probably come up with every conceivable solution to the problem. So we came up with the last two that exist, I think. And our theme at the last hearing was, all right, we've tried these across-the-board solutions. We've tried very ambitious solutions to all the problems, and they simply don't work because too many people find too many reasons to disagree with them. Let's try to come up with something that will fix a good deal of the problem with a minimum of fuss, with an economy of words, and see if that works. So we came up with two alternatives. One was one which at first blush sounds like anathema to music publishers and composers and songwriters, which is let record companies sublicense the rights. But in fact, to us, it sounds like not such a bad idea because in fact, it's what's going on to a large degree already. Section 115, in fact, permits a record company which has obtained the right to cut a record of a song to sublicense to an online music service the right to make digital phonorecord deliveries of the song that the record company has recorded. Record companies do that often. They don't always do that. They're afraid to do it, for example, with a new service that they're not sure is going to be good for the money because they're afraid they'll be on the hook for the royalties of their sublicensee. They're also not so sure they want to do it in circumstances where it's not clear whether particular activity is within the scope of Section 115, and that's a big issue. But the fact of the matter is that there is a provision in existing law which seems to let them do it. It seems to be working in large segments of the business. Why not let them do it? And why not build in some things to make it work better? For example, build in a provision that gives the record companies the safe harbor they need so that they're not on the hook for their sublicensee's royalty payment if the sublicensee doesn't pay it. And let's give music publishers and songwriters some comfort they need by putting certain obligations on the record companies to promptly pass on all of those royalties to the people to whom they belong. That was one solution, which literally would take just a few strokes of the pen to fix. The other solution was to go back to the sound exchange model, a blanket license, a single collective to take in all of the money and disperse it to all of the copyright owners. It works reasonably well with 114. Whatever you think of the rates, the mechanism seems to work well. Why not try it with 115? And finally, we told Congress, you've also got to clear up these rights issues. When is a download a performance or isn't it? Is a stream a reproduction or isn't it? Is it exempt or isn't it? And those are issues that still need to be determined, although, as I said, maybe one side of that equation has now been resolved. So there's much that needs to be done. It's not at all clear to us whether there's a political will to do it right now. Certainly, it seems to us that DEMA has decided to put most of its eggs in a different basket this year, and I doubt that it's going to have any political capital to spend on music licensing with all of the capital it's spending on webcasting. But we'll see. But because we have spent so many years basically putting our regulatory activity on hold in the hope and expectation that Congress would act, and because it's far from clear that Congress is going to act, we have resolved this year to do what we can on the regulatory front to clean up as much of the mess as we can. How much we can clean up remains to be seen, but we are going to take a fresh look at every issue. While we may have had a rather jaundiced view in the past of what we could do, we're going to try to walk into this again with our eyes open for all options. What we're probably going to do as a first step, well, first step may be, there are a couple of notices of proposed rulemaking which may get out there soon. Whether they'll come before or after the next step, I'm not sure, but we are probably going to hold a round table in June, at which we invite interested parties to show up and share their ideas on a number of issues, which will be outlined to some degree in a notice we'll publish, hopefully within the next couple of weeks. And we are very hopeful that this year we can take a major step forward in resolving as many of the issues with respect to 115 as we can. I was going to talk a little bit about a ringtone decision, but I think I probably used up all my time. So I'll just give you the 2-minute version. A new provision under the copyright royalty judge law says that when there's a novel question of law, the copyright royalty judges are to refer it to the Register of Copyrights, who gives them a binding ruling. We have 30 days to give them that ruling. Last fall, we got the first 2 referrals within a couple of weeks of each other, which really made us scramble. The first one had to do with ringtones, and the question was, are ringtones within the scope of the Section 115 compulsory license? So we had briefing on that, we had hearings. Music publishers argued vociferously that ringtones should not be within the scope of that statutory license, that the licensing in the free market is working well and efficiently, and in fact they're getting better royalties in that marketplace than they get under the statutory scheme. They reminded us that the Register of Copyright has said in the past that as a matter of policy, ringtones shouldn't be covered by the compulsory license because the marketplace is working so well. The problem with all of that was that they were really talking to us as policymakers, and our role in this kind of an activity is very different. Our role in that activity was to interpret the law as it is, not to come up with the law as we would like it to be. And the way we read Section 115, it was clear, and everyone, I think, admitted, that ringtones do qualify as digital phonorecord deliveries. The major issue was when a ringtone, which is just a snippet of a sound recording, maybe 10 or 15 or 20 seconds out of a recording, is that such an alteration of the original song that it falls outside the scope of the statutory license? For example, is it a derivative work? I don't have time to go into the legal analysis, but I'll just say our conclusion was, however reluctantly we came to it, Our view of the law was ringtones are DPDs within the scope of Section 115. They are subject to statutory licenses. Music publishers have appealed. That appeal probably will not be heard until after the copyright royalty judges issue rates for ringtones, which will be at least a year from now. Well, again, it may be regrettable in terms of what was happening in the marketplace. It was the only answer we thought we could give based on our reading of the law. If there's a silver lining in this, the one thing I would urge music publishers unhappy with that decision to do is make your case to the copyright royalty judges that the value of a ringtone is considerably more than the value of a full download. In the real world, facts have shown that, contrary to what you might imagine out of logic, ringtones are worth more than pure downloads. People pay more for ringtones than they pay for downloads. So with that kind of record, why wouldn't the copyright royalty judges set a royalty for downloads, for ringtones rather, that reflects that market rate? I see no reason why they wouldn't, and that's the case I'd urge them to make. I think I've taken all my time. I know we arranged that if I went over time, I'd just hang around till after the next panel for be part of the question session there. So shall we do that?
Yes, that'd be great. We're going to go right into the next panel, and then thank you so much. So I'll just ask Walter to bring his panelists in, and we'll go right into this next panel, but David is here to answer any other questions that come up, since this panel will cover a lot of the issues that he did talk about. Okay? Walter, do you want to have folks sit down?
Can we sit next to each other? No. That's cool. All right, let me warn you, I don't share the mic. Oh, okay. Thank you very much.
It's not as if you and I are going to be the ones talking over each other.
If you want, I can do that. Be fun. Where's the end of next? I just need to plug this in.
All right. Well, good afternoon. I hope everyone's still awake. I know that I'm tired, to say the least, but I've been a fairly productive group of panels today, in the sense that I really felt that there was a good range of opinion. It was done very civilly, which is important. I thought people made some great points, and I just think the general tone and substance has been great. And I also want to thank David for, in his usual fashion, taking a lot of very complex issues and not only reducing them to making the issues understandable, but actually having the guts to propose solutions. And I think that, as I always say, I always believe the Copyright Office is one of our best bureaucracies. And I think David really does an outstanding job in terms of demonstrating this. So, since we're the last panel, hopefully not the worst, but certainly the last, I thought we'd try to make this a little bit more freewheeling. Hopefully we'll have some fist fights up here and people will throw stuff, and we'll just absolutely abandon all standards of civility this afternoon. But I thought what we'd do is just really have more of a general kind of discussion about licensing, and perhaps sort of overlay this discussion on what everyone else has talked about, sort of building up to this. So as we had more specific discussions of issues from everything from webcasting to net neutrality and some of the 115 issues that David just covered, that we can kind of put these into some form of sort of context so that maybe we can, in a sense, sort of summarize everything that's happened to date. So I thought the best person to open this up would be Jewel. Well, no, you can get picked on. But anyways,
It's the first I'm hearing of this. So.
well, I like to. I always believe you don't waste the best material in the green room. But just generally from Microsoft standards, I mean, what are some of the challenges that Microsoft encountered when they first began to license music?
Well, before I get to that, I want to thank David Carson for saying I'm the father of orphan works. Somebody behind me said that it's all about unlocatable parents, unlocatable owners. So I think I'm more like the deadbeat dad of orphan works, actually. So
Can you be the father of orphan works?
yeah, exactly. Microsoft. What problems do we experience in licensing? I think they are very similar to the problems that any new music online music service has experienced in trying to license music. And the problem is essentially the underpinnings of everything David Carson described. I always like to say that the music industry, the music copyright structure, it's a game of like three-dimensional chess. It's actually there's four dimensions that you're working with all this stuff. There are two different types of works: sound recordings, musical works, sometimes embodied in the same thing. I taught copyright at George Washington in the last 2 years. That was one of the hardest concepts to get across to people, the notion that something has a dualistic nature. There's two different types of works, two different groups, the different copyright owners who own those rights. And then, as David was pointing out on the top of the musical work, there are two different middlemen who own those rights on behalf of ostensibly the same owner, usually joint owners of publishers and songwriters. So there's that complication. Different types of rights, which sometimes apply, sometimes don't apply, depending on who the owner might be, what type of work it might be. There's performance rights, but there's no general performance right for sound recording, but there's performance rights for musical works. There's reproduction right. Then there's the question, the problem with the online space is that it sort of pushes everything together. It's what I like to call quantum copyright, right? Down at the digital bits, things get very, very strange, right? Is it a stream? Is it a download? Is it a particle? Is it a wave, right? And depending on how you observe that question, I remember these meetings we had in the Copyright Office when I worked there before the beginning of this year. You would go into these meetings and people would argue whether some particular service makes streams or downloads. And I would come out of those meetings thinking, it's a download this time. It's got to be a download. We go in, talk about the same service. Next meeting, I'd come out thinking, it's a stream. And at the end of the day, it was really almost, you were making a political choice about whether you were sort of favoring ASCAP or whether you're favoring the Harry Fox agency, because that's where it would boil down as to which middleman whose whole existence depends on a particular view of the world or interpretation of the world comes into play. So you get this complication. It's this intersecting lines. And the question for a music service is you just want to get the music online and out there in whatever convenient form the consumer wants. The consumer doesn't care about any of these distinctions. The consumer wants the music in convenient form. Sometimes they want streams on demand. Sometimes they want downloads. I used to be a subscriber, and this is no slight on them, I used to be a subscriber to Rhapsody, which I thought was a very good service. I just didn't really have time to use it. But when I signed off, they had a great little survey at the end. They said, why are you leaving us? And basically there were only two questions. You have more time than money. You have more money than time, right? I sort of checked the last one because I'm older and I don't have enough time to do this. But you can see that there's different segments of the population that you're trying to serve. The kid in college has more time than money and likes to download and likes to mix and likes to do that stuff. People my age just like the stuff pushed to them more frequently and having sort of access to the celestial jukebox, as it says. But those very much don't match with the structure of rights and the marketplace structures that have been developed over time. So the main problem is sort of cutting through that morass. And it's taken a lot of work. I think, as the brief for this panel has showed, that we've come a long way. In fact, if you think about all of that morass, the fact that we actually have new services that are licensed, consumers are paying for music, that music is flowing back through to artists and to record companies, the fact that that's happened is something actually quite startling. It's sort of like seeing a mountain walk. You see something that sort of is astonishing in light of all of these problems. And it's sort of a lesson for us, at least in my old job in the policy realm. It's very hard to predict how things happen. People in markets and participants have a way of sort of routing around all of the stuff you try to do in the law or the regulations to get to a result. So we'll get there. How we get there is still sort of unknown, I think, as everyone was talking about on the other previous panels. We don't really know. But the main problem, I think, is that the structure that we had that was built and worked reasonably well for the physical world just really did not mesh with the online world. And we've now are still engaged in the process of sort of cutting through all that and trying to come up with ways to make it more and more simple and more efficient, because that's ultimately where we need to go if we're going to have a serious copyright system to support the production and dissemination of music.
So, Fred, you've worn many hats in the music industry. Do you have any kind of historic perspective in terms of how we got to this point, why there's multiple stakeholders? I mean, obviously, you represent one of the major stakeholders. Why are there multiple stakeholders? Why are there multiple middlemen?
Boy, that's a $1 million question, isn't it? Well, first of all, being a rock and roll relic, I can just say that, first of all, the way the whole historical background of the music industry kind of grew brought us to the stage where we are today. And, you know, I remember when people said there was only Tin Pan Alley and there was only one Performing Rights Society, and then there became two because there was competition, because the minority music wasn't affected, and BMI was born to address ASCAP's situation in the radio world. And from that point of view, competition was great. Then the record labels came into play, and the competition with the record labels grew, and they become multinationals, and they've had a hand in creating great music for great generations, as the PROs have been around, and as the publishers have been around. And I think we've all, over this 50s, 60s, and 70s for sure, that was my decades, helped generate great music. But what we've got today is a whole new different world. And the world is that we have the digital age. Very revolutionary, very inconceived in the sense that the record industry and the music industry and even the creators just kind of let it happen. And now we face what we all look at and say, what are the solutions to all these many problems that are coming at us? What's a stream? What's a download? Creators are looking at this and going like, wow, what does this have to do with what I do? I just write music. And I say that because the creators on one side have to deal with things that they never had to in the past. There was always somebody taking care of them. And today they have to become more aware because they have to become everything. They have to become their manager. They have to become somewhat of a lawyer. Definitely they have to know about technology, which in the past, if they were in the studio, they always had an engineer, and they always bought the time with the engineer to take care of their sound, and that's as far as it went from the techno point of view, unless you were live and you had a mixer in those days. And so I think what's evolved here is a great new educational forum for the creator, which has also educated the music business as a whole to understand what we have. We have a great revolution here of technology, which has presented us with a million problems. And like David Carson pointed out, there's some of us who can deal with it, and some of us who can't, and some of us don't want to give up what we have, and some of us who will, because it's going to happen. But technology is definitely create a new threshold for the creators, and I think they're the ones more than anybody who are really affected by this. And being a creator myself, when I got into business, I feel that that's something that we should never lose. We should always support the creative process, because like somebody said today here, the car to me is the creator, the fuel to me is the money. If they don't make the money, there's not going to be any car.
Who has the drugs? I'm just kidding.
What drugs?
Or the dead body in the back.
Yeah. You know, Steve, you've been involved in an interesting process because you've been intimately involved with the creation of a new stakeholder, namely Sound Exchange, a new licensing body. I mean, notwithstanding the fact that, you know, Sound Exchange, of which I'm also a board of director, you know, is operating within the mandate of a statutory language. When you know, as your experience in Sound Exchange has gone forward, you know, how have you drawn on the experience of organizations like ASCAP or BMI or CSAC or even some of the foreign PROs in terms of trying to conceptualizing what you should be doing on a licensing basis?
Well, I think it's a little bit of a different exercise just because, as you say, everything about Sound Exchange is really pinned, or everything about Sound Exchange is pinned to the statutory license. I mean, there's not been traditionally a lot of licensing outside of that. There haven't been any, really. We've talked from time to time about trying to set up, you know, clearinghouse licensing for different kinds of uses that you know, go unlicensed, because you know, it's all about finding alternative revenue streams right now, and if we don't find those, we're all going to be you know, in pretty deep trouble pretty quickly. And you know, all of these legal issues are interesting, and probably to the outsiders, it's there's some entertainment value in seeing people within the industry fight among themselves about whether a ringtone is a download or a performance is a download or everything else. But at the end of the day, we need to figure out how to answer the questions quickly, come up with a simple way to license, and be able to get more music pumped out there in more different ways. We saw some of our survey evidence in the past year showed that last year the consumption of music increased by 8%, but the legal acquisition of it went down below 50%. And so, I think a lot of people on this panel and other panels are pretty fond of pointing out that it's not that people's desire to hear good music is diminishing. It's just that they're not buying it or listening to it in ways that ultimately help fund the creators, which is the most important thing.
So, Michael, now that we've sort of laid the foundations of what various licensing traditions we have, what really is the frustration with the Consumer Electronics Association in terms of trying to license content, unless you're completely happy and satisfied?
Yeah, well, I think there are a couple of points. Right, and first of all, Fred was talking about how these new technologies, cause a million problems, and it's true. Technology is, by its very definition, disruptive, and it changes the way we do things, and it changes consumer demands, and it changes businesses. But I would also like to propose that if it causes a million problems, I think it also creates 10 million opportunities for artists,
We agree.
and creators.
Absolutely.
And consumers' demands are different. They want these friction-free experiences, and they want convenience, and they want to be able to acquire their content and then use it in ways they think is fair. And the key is working out the mechanisms for those things. But if you look on the plus side, you see artists empowered as never before. I was talking to an artist before this morning, and she was talking about how the weirdest thing today is to see these bands you've never heard of, and then all of a sudden, boom, they're selling out a 1,000-seat venue, and you're like, how did they do that? And the way they do that is, they have the street teams, and they get the word out, and they really use the digital mechanisms available to them. You look at network music and some of the things that they do. They're amazingly creative about doing it, and the record shows that it works. Ringtones. There are all these issues with ringtones about how you divvy up the pie, and that's very contentious. But hey, this is a business, an $8 billion worldwide business that did not exist like 5 years ago. So, there are questions about how do you monetize the things that consumers want to do. There are questions about how do you divvy up the revenue. But the good news is that the pie is growing, and I think with these nascent services, the key is to make sure that creators are compensated fairly, because again, without creators, none of this happens. That's number one.
Okay.
But of course, and that's fundamental. Without creators, the neat products that we make would be very, very quiet. But on the other hand, I do believe that these nascent digital services are going to be the salvation of the music industry, and it's important not to do things that would smother them in their crib. And we don't have a position currently on the whole web radio issue, but I thought that the songwriter that was in the panel right before lunch was incredibly compelling about the impact these new services have on independent artists. So it's important to strike that balance.
So, Joe, this has all been a setup for this question, because so often we hear some observers say that basically copyright law is obsolete or it's broken. I mean, do you think that the system needs to be reformed in order to expedite licensing, or is the system fine as it is?
I can't make up my mind. So here are some things that people might want to consider. It's just too far away. Okay, so on the one hand, the system is just ridiculous, right? And it's ridiculous for a reason, which is that each of these rights was extended to musical works at a different time, each of the Section 106 rights, and in a different way that was sort of historically contingent on the way that markets developed. And then in each of the cases of each of the rights, there was perceived to be a need to correct some market overreaching, and so we got the mechanical license, and then we got the ASCAP and BMI antitrust consent decrees, and then we got the statutory license for the digital performance right. And that each piece of that seems reasonable in historical context, but when you add it all up, there are just too many middlemen, there are too many costs. People can't figure it out. And so that's a pretty good argument for needing to simplify it. But I just want to now pose a couple considerations on the other side, and one consideration that I don't know which way it cuts. On the other side, so suppose we could come up with a perfect, streamlined, beautiful, unitary, single system for licensing all the rights in music. These problems that have been problems historically about market overreaching will now be back to confront us in full force. It's one thing to say that a rate should be willing buyer, willing seller, but if you've combined all the said all the rights can be administered by a single party in a unitary scheme, then you have potentially, again, the set of circumstances that cause the antitrust consent decrees against ASCAP and BMI to have to come into being. And you have, in addition, when you've put in place a nice, sleek, low-cost, friction-free administrative scheme for monetizing and licensing all the rights, you have more squarely to confront questions about fair uses and personal uses, and little kind of nooks and crannies in which new technologies could make their home, because when you have a nice, sleek, unitary scheme for those sorts of things, those uses are now exposed. And the system just works very differently than it did before. And I don't think that there's been really any thinking about how to do that in that context yet. So those are the considerations that might cut on the other side. I don't necessarily think they're dispositive, but they're things to worry about. Then the thing that I think is just interesting, and I don't know what I think of it yet, really, if you ask why it's such a mess right now, the music licensing system is such a mess right now because not of all of these zillion-page sections of the Copyright Act that directly govern music, but because of Section 106, which makes this really fundamental bifurcation between reproduction and public performance. Okay.
This one might be better.
Maybe this one's better? Okay. Because I'm not going to go like that. So Section 106 makes a fundamental distinction between reproduction and public performance, and incredible formalisms then hinge on that, right? So every time you have like something being reproduced for 30 seconds or a millisecond somewhere on some piece of equipment, David Carson and his co-workers at the Copyright Office have to engage in days of testimony and scratch their heads about whether it's a stream or a download. That's not because sections 115, 114, whatever care about that. That's because section 106 cares about that. And that fundamental set of distinctions that the basis of our entire system of copyright may in fact be what's causing so many of the problems in the particular context of music, which raises a real question about whether maybe the best copyright system for music is some other copyright system than the one we have. And I don't know what the answer to that is.
Seems to be, yeah. I mean, I understand what you're saying, but let me just ask this one question, if I may, to Fred. We had a recent decision in the Southern District of New York in litigation that was involved with ASCAP in terms of, just the court's decision was to make the distinction between downloads and performances. I mean, that being said, Julie raised some very interesting points. So let me just ask you this question. Notwithstanding the fact that case can be appealed, let's say hypothetically the decision stands. And we had David Carson's earlier remarks about 115 reform. If you take the decision in hand and combine that with some of the economies of scale that have been proposed for 115 reform, does it address some of Julie's concerns? Does it make licensing that much easier in a digital sense?
Well, first of all, let me just stress that I represent BMI, and ASCAP brought the lawsuit, so I just want to make that distinction here. So I'm not used to defending ASCAP and what they do. So I don't even get paid for that. Jesus.
That wasn't my intention.
I know. But I think the reason why, and I think it's a legitimate reason, that ASCAP brought the lawsuit is because throughout the world, and David, you can correct me on this, there is a public performance and a download in other countries, and we get paid for it. Our songwriters get paid for it. And so the premise here was that there was a right, because there's a right, as my attorneys say, in a download, because there is a transmission from A to B for the download. And under the copyright law, the transmission is a public performance. So from the legal point of view, that transmission is a download. So the PROs felt, number one, there are copyright societies throughout the world that are paying, I believe, 25% of the total 100% that they get on downloads to the PROs, because they have joint mechanical and PRO societies together, and they divvy the money. So we felt that there's no reason in this territory why we shouldn't have the same. So I think ASCAP decided that it was the moment to create a marketplace solution by going and having a court decide what, if there was a right or not. Now, we still feel that there's certain elements, and I'm not going to go into this because I really don't want to identify them at this point, that are being so-called hurt by this. And I mean hurt in a very strong sense. And those are people who have work-for-hire projects out there, because they're work-for-hire, and most of their income comes in from, on the download, from the public performing right, because they just get paid a little bit up in the front end, but the back end, they get revenue from us to survive. And they're going to be hurt by this. And that's why I think it's a legitimate claim. I don't agree with the ruling, obviously, but does it make it easier for the marketplace? I'm not sure yet.
But you want to jump in? Sure.
Yeah, I just wanted to say I think Julie's larger point is the correct one. However, I don't think it's a problem of the fact that there's a different right in Section 106, because the problem stems from the fact that those rights, those separate rights, are owned by different people, whether it be middlemen or different copyright owners. Because you have the same separation of rights in the motion picture industry, in the literary industry in terms of plays and musicals and performances, where you can have two separate rights. It's easier in those. It's motion picture in the record industry. Another example. There's no problem with this in the motion picture industry. Nobody spends time worrying about whether watching a film on MovieLink is a performance or a download of the film, because they're owned by the same company, and you can get the rights. You can get all the rights you need. I mean, I remember in private practice, most of the clients in these transactions didn't care. They didn't even care whether it was performance or reproduction. What they cared about was they needed all rights necessary. And most contracts say things like you have all rights necessary, including without limitation those rights. So it's much more, I think, of a function of the structures built up around the rights that cause the inefficiencies. I mean, the antitrust consent decrees that govern people like ASCAP and VMI prevent them from licensing the reproduction right. They cannot do it. They cannot bring the two together. I assume the Harry Fox Agency and the individual music publishers are reluctant to get into the business of licensing performances for antitrust reasons and otherwise, because that's not the way that they're structured. But this is a function of the marketplace that's been built up, which has a heavy dose of regulation on top of it that controls what happens. So that's why, and that's actually probably a harder problem to solve because of that than it's simply a statutory change in the structure of the rights granted. It's the problem of copyright law. I mean, as Gary Shapiro said, you should paint a picture with your words. The picture I like to paint about the music industry and copyright law is the one of a house. We built a pretty nice house in 1909, but it didn't have indoor plumbing and it didn't have electricity. So we had to base it, and it got grafted onto over 65 years. We had to raise it and build a really cool house in 1976 that had, shag carpeting, and it had, some electric. It had a refrigerator and a trash compactor and one of those goofy intercom things that no one ever used. And we thought it was really cool. But basically, since 1976, we've been putting additions onto it every piece. We put an addition in 92 called the Audio and Recording Act. We put an addition in 95 called the Digital Performance Rights Act. We put the DMCA in 98. And so now you've got this sort of ungainly structure with lots of people living in it. That's the problem. Everyone sort of moved in and living in these various things and somewhat used to it. Now you've got all these people sort of just coming from the neighborhood saying, this looks like a cool house, maybe it has something for me, and they're coming in, then they're finding that they're having trouble finding a place to stay. And the question, I think, is, do we raise the house and get all those people who've been living in, put them in the street for a while, and start over and build another cool house with, broadband and Cat5 cabling throughout or something, internet, wireless, stuff like that? Or do we try to just continue to live with these piecemeal additions and, refinish the basement and do things in the house? And the really hard question is because you do have all these people who have very vested interests and legitimate interests, not just interests that they're trying to protect because incumbents protect their interests. They have money invested on this and they have stakes involved that need to be addressed in some way. So,
hey, do you have a garage? We need it for the car.
Yeah, that's right.
No, the band's playing in the garage.
So without disagreeing with anything that Joel just said, I just want to point out that when these large music entities are licensing as between themselves, they may not care what the rights are, but they care very much when they can use one of those rights as the hook to sue some startup tech company or to bring an indirect infringement suit because something's been reproduced in RAM for 30 seconds. So I do think that a tenable solution to these problems needs to extend as far as considering the rights. If you take a broader view of of these new people who might be trying to come and live in the house.
But that's not really. But it's not really unique to the music industry. There's other areas of copyright law.
Cablevision just lost a district court ruling in New York because their DVR does that.
But I also see the just in a general sort of just in a general way. You can break down a lot of the issues in software licensing too that become equally contentious. And sort of parallel a lot of the music issues as well. Who'd like to defend current copyright law?
Well, I guess here I go again. Do I get paid for this? Always in the money. No. The truth is that from the PRO perspective, and I can only speak for BMI, we represent 300,000 songwriters and music publishers and composers. And it's free. It's a free entity. They come to us because we go out and protect their rights. Not only do we protect their rights, but we help them earn money. And the important thing is we're part of the copyright law. And we've grown in the last, I'd say, 18 years between 6 and 12% almost on a yearly basis. That's phenomenal growth in the business. And let me just tell you, I think we're the only area that's growing right now. And I may be wrong, but I know we are growing, and I know ASCAP's growing, and I know CSAC's growing. So we're doing a great job in the business of collecting money. And I say, we have 4,200 digital services that we license. We work out deals with them. We have 35 different deals that we do with different caliber of people, the large earners, the small earners, the start-off companies, and we try to work with them. They're our customers, and we try to help them. But we do it for the songwriter, and we do it for the fact that long-term, we all have to work together. And I think that's an issue that works for us. And we're not antagonistic, and I see every litigation that we do comes through my desk. And I make sure that we have legitimate claims against people who just don't want to pay. And even if they don't have the money, we sit down with them and we try to work out a deal. It doesn't always happen, but the majority of the time, we have the sensitivity to do that. And I think that's what's driven our side of the copyright industry to be so productive and grow so much. So yes, I think part of the copyright industry does work, and I'm here to defend that.
But, if I may say, the one advantage that ASCAP, BMI, and CSAC have, though, is the performance rights universal across the board, where with Sound Exchange it's limited. So, to a certain degree, and I think we see this time and time again, the valuation of the record companies versus the publishing companies, is that the publishing companies are always going to have more inherent value because their performance right extends across all form of media. Now, for example, Sound Exchange can't collect the 114 rights limited for audiovisual works. You can't do anything with audiovisual work, where every time I watch The Sopranos, I hear Johnny Thunders or Alabama 3, one of my favorite bands of all time. Hopefully they're getting paid every time.
We're happy. I'm sorry for Sound Exchange. We don't look after that right.
But I'm just saying it's the one distinction.
Sure.
But the biggest thing is radio, obviously,
right.
Where if we're going to fix the copyright law, let's start there. You've got obviously, kind of the people always paint the record companies as the dinosaurs. Next to the the broadcasting companies, we look like toddlers in terms of them being, stuck in the old world and trying to, preserve their very significant margins and things like that, all off of the music that artists and record companies are creating. So that's one inequality that probably everybody up here could agree on. That should be addressed.
I know you want to jump in, but I just would like to add. I mean, people that don't think the broadcasting industry is profitable. I mean, I'm watching the attempt to take Clear Channel private, which is going on with some of the biggest venture capital in private equity companies in the world. I mean, Bain and Company, Thomas Lee, et cetera. And what's interesting about the whole process has been like the CalPERS and the big pension funds, Fidelity Investments, who everybody's familiar with, getting involved in this process and trying to stop it because they think the valuation is too low. So, I mean, clearly, there's underlying profitability if some of the richest entities in the United States are fighting over who gets to own Clear Channel at what price at the end of the day. But I know you wanted to jump in.
Yeah, I actually want to tie two things that might not seem to go together, which is something Julie said, a good clarification of my point about how sometimes all you need is some slight hook, some slight reproduction out there that you can base a whole lawsuit on and actually gain a very good competitive advantage vis-a-vis someone else who's making use of your work, even if through some sort of temporary reproduction. And I want to tie it to what Steve just said, and I'm going to ask probably a provocative question to Steve in the recording industry, which is, if you were so concerned about getting some leverage over radio broadcasters, have you ever considered suing them for essentially blowing through their ephemeral recording exemption in 112 for all of the copies of all the songs that they make in their digital databases that they Clear Channel send through all of their stations throughout the world? It would seem that there might be a claim there for reproduction, again, sort of even however temporary, a sufficient claim for reproduction right that would put them on the hook for, as we heard from Gary Shapiro, they use a lot of works for infringement that's very, very high and might make them think more carefully about agreeing to legislation for some sort of statutory license, or at least give you some leverage over their business. Just a thought.
Well, sounds like you've got some evidence that would be useful for us, so maybe we should talk afterward. It's a difficult question to answer because it goes into legal issues and things like that. That
just
frankly,
give the lawyer
privileges,
Just give the lawyer to say the discovery would take too long.
Yeah, right.
Michael, you wanted to jump in?
I mean, we are all in favor of rationalizing the copyright system. Because the system that works means more content and more people enjoying our products, and clearly there are major issues. I have to say we're a little bit hesitant based on our experience last year with the Copyright Modernization Act, where in name we were in favor of it, but we ended up opposing it because it discriminated against services that enable consumers to make lawful home recordings of transmitted performances, like this XM device. And this was extraneous; it didn't need to be in there, but somehow it just kind of got tucked in there, as often happens with legislation.
Now, who would do that?
Let me
explain what that issue is, though. Just
right.
So the people who aren't familiar with that will understand what you mean.
And this is this device allows consumers who receive XM radio to time shift their lawfully acquired content to listen to it at a different time. You can't take stuff and upload it to the internet. You can't take your music and put it on a CD. It's like a Roach Motel. What comes in doesn't go out.
Kind of like an iPod, right?
Right. And
did you clear that with the branding?
No
people?
real value there.
Right. And then that would have been obviated by this Copyright Modernization Act. But again, just to caution you, let me mention one other thing or set of things that was in there. And for the artists and songwriters in the audience, this should be very interesting to you. In this piece of legislation, which came very close to going through and came before the full committee, also contained some other stuff that you may not have heard about. It would have preempted state laws that were used to force labels and publishers to pay artists tens of millions of dollars in back royalties. It would have basically undercut the $50 million settlement between record labels in the state of New York. It would have given record companies the power to divert mechanical royalties from artists and songwriters. It would have allowed designated agents to charge artists and songwriters for certain fees to be used for things like lobbying, presumably lobbying for provisions, just like that. And so the point is here that it's a sausage factory. And stuff happens, and you got to keep very aware of the process because it's very easy for you to come out with something and ingredients, not sausage, that you're at the end of the day not going to like. So it's a
Now that
difficult
we've-
process.
Now that Michael's gone through a spin sheet, let's talk about an interesting little thing I saw today, which was a survey by a well-respected company that found that XM and Sirius users are 30% more unlikely to buy music than others. And that's before they get their hands on devices. Michael's right that these devices allow you to time shift, but what he didn't tell you was all the other things that they allow you to do as well. Because the devices aren't made for time shifting, because you don't have to listen to the program that you record. You just pick the songs from a list and select those and library them, much like you would on an iPod, and there's no real... people try to put their stuff onto devices, not take them off. So the mere fact that you can't take it off really, doesn't matter very much. But this is about companies who are using music stepping up and paying what they should. And it was precisely this performance distribution distinction that XM was trying to hide behind. Which was the whole basis of the lawsuit, basically contending, well, we have our license for performance and that's all we need, when they were engaged in much broader use of the music, and that's what led to that.
So does the ASCAP decision help in that?
Does the decision in the ASCAP rate court on downloading
Versus performance?
I don't think so.
Yeah, I don't think so.
Yeah, I think it's a different issue.
If I could just add a couple of things. First of all, the companies that use the music should step up and pay. And XM and Sirius pay tens of millions of dollars in performance royalties every year to the music industry. They're the largest payers of performance royalties by far. Second of all, it allows consumers to record things. You can record off the radio, as consumers have been doing for decades, as many of you may have done when you listened to Casey Kasem's American Top 40. That has always been around. And number three, you're talking about hiding behind the law. There's a law. There's a law called the Audio Home Recording Act, by which our companies pay a royalty every time something like this is sold to Steve's companies. And we agree not to allow them to make copies of copies, not to allow them to export music. And in return, the agreement was that we get to go forward and manufacture these. So there was a deal, and there's a law based on this deal. Finally, if I could just add, I do so many of these forums, and I hear so many complaints about XM and Sirius. I hear complaints about Steve Jobs and Apple. Generally, their prices are much too low, and we've got to force them higher. I hear complaints about internet radio, except it looks like we took care of them for the time being, so that's okay. And I would just again warn that these services, I think, have huge potential for the music industry, especially for niches. Like if you're interested in listening to jazz, and I don't mean light jazz, the guy with long hair who plays the clarinet. I mean but if you want to listen to like Miles and Coltrane, man, I hope you have internet radio or XM or Sirius, because you're not going to hear it any other way, and provides huge exposure to artists. So again, I would urge everybody not to look at these nascent services, especially ones like XM and Sirius that are hemorrhaging money, or internet radio or whatever, as piñatas to be whacked until every last piece of candy falls out. I mean, there's got to be a balance here, and what that balance is tricky. But I think everybody has long-term interests in these new formats going forward and thriving.
All right, so Julie, what's the best way to sort of bridge the policy gap between Steve and Mike? I mean, how do you reach a middle ground? I realize it's a very difficult question, but is there any models of trying to reach a middle ground of this? And I understand what Mike's saying in the sense that they're paying two different royalties, namely the performance royalty under Section 106.6, as well as the royalty under the Audio Home Recording Act. But I mean, is there any historical context we can put this in terms of trying to reach resolution on these issues?
The historical context suggests that the resolution gets reached by some sort of market-correcting regulation or antitrust consent decree rather than by the parties themselves identifying a middle ground, sadly. And I haven't seen much hint of it yet, also, sadly. So,
your point's very well taken in the sense that ASCAP and BMI are subject to an antitrust provision. We've had statutory licenses evolve over the course of the 20th century, But in a sense, I think, and I don't want to put words in your mouth, but I mean, in effect, if people are able to do this and reach some way that works for all parties, I mean, they're essentially doing it in a way that hasn't been done in the past. In other words, if the parties are able to reach solutions amongst themselves, they're actually getting away from the historic way that things have normally been done in copyright law, which is either been through litigation or forthing through legislation. So people aren't as bad as we think they are, I guess. That's my point. I don't know, difficult question. But does anybody have any sense of how we compare to other countries in this process? I mean, I know that, for example, I've heard people recently say that webcasters should move to Canada. And these were people who were for the war. No, that was a joke. But I mean, I just came out of a seminar up in Toronto a couple of months ago where I don't think people have any clue how many royalty systems there are in Canada in comparison to the United States. But I just wonder if anybody wants to take it on, because I think people would be absolutely, it's edifying, but people would be really surprised if they learn what the licensing schemes were in different countries.
Well, we have a gentleman from Canada here. I don't know if he wants to make any comments.
Well, I'll say a couple points. First, on the question of sort of Section 115 reform and the split between performance rights and reproduction rights that is causing problems here in the U.S. That's typically not present throughout the world. I mean, we did some research for that when I was at the Copyright Office last year in talking about this. Most of the world, there's usually one collective or a collective that's associated with another collective who deals with both reproduction and performance at the same time, and the licensing seems to be working better just because they can license a service even though it might be doing one or the other, or there might be some gray area. Now, how they split it up between reproduction and performance, split up the money, who gets the money seems to be somewhat arbitrary and sort of just people pulling numbers out of their hair that one's worth 75%, one's worth only 25%. That may be a question of which artist gets paid, and how they get paid may be a separate question. So I think it's, in part because they have more experience with collective systems than we do here in the U.S., they're a little bit better at it. But that raises sort of other problems, which is when you have collectives in a lot of, especially in Europe, first of all, there's the problem of getting these royalties back to U.S. artists, as we heard a little bit about this morning. That's always been sort of a problem, especially vis-a-vis Europe. But then there's this problem, when you have a collective that gets into existence and has been in existence for 100 years, again, they have a motivation to stay in existence. And a lot of times they have a motivation to reinterpret the world to make sure that they stay in existence. And even to the point where, it's very hard. I mean, Steve could probably testify. It's very hard to actually keep a collective together because what value are you adding to the individual creator and the individual artist in joining the collective? And Fred probably knows this too. There's a really competitive marketplace for attracting people to stay in your collective and use your services. And there's, it may or may not, it can fall apart pretty easily if you're not adding that value.
Right.
And there's a lot of, as I look at the situation, particularly I spend a lot of time doing the DRM debates in Europe about interoperability, and what I see there is the undercurrents, not really reported very well, is that there are large collectives in Europe who would not like a world where an individual artist can actually connect with their users directly and license and exchange and for value their music. No. And because those collectives in large part exist because of all the inefficiencies thanks to in the old technology of doing that. So if you remove that inefficiency, you get a lot of tension between actually what an individual artist and his or her users and consumers and fans would want to do and what that collective might want to do.
Are you suggesting the U.S. collectives would like that world?
I'm saying that all I'm saying is that there's oftentimes we think that these problems can be solved with collective organization and collective management in some respects. But my point is that everything has its costs and benefits.
Right, and it creates other problems.
Yeah, and sometimes you have to. I mean, it's interesting to look behind the motivations and the incentives from folks, and that collective license. And I think my personal view on some of these things, a lot of the problems we have in our music industry today are in part the result of having collective systems built for different times. I mean, that just creates the natural inefficiencies.
But I just want to jump in for a second. Is it correct that there's some countries that actually ban their members from directly licensing with folks?
Well, yeah. I mean, that's essentially that was the primary competition problem with ASCAP in the 40s. The primary problem was not a collective versus user
I'm saying
thing.
2007. Are there countries in the world that do not permit their members from licensing directly with people.
Well, they do. Essentially, you're allowed to have an exclusive arrangement between a collective and an artist, meaning that artists can only license. You can essentially sign all of your rights to the collective, and the collective is the only person from that point forward who can license their rights.
There's also some uses abroad where the collective actually has a legal mandate to collect for certain things, and nobody else is allowed to collect for it.
Right. And they have exclusive rights where we have non-exclusive rights. Very big difference here.
So this is like the guy in Finland who has his own website, but he can't license music to his own website issue. Not to pick on the Finns, because I love them to death, but, but that's always the story. I know you wanted to jump in.
No. Again, I think the point's been made again and again. The U.S. copyright law is at this point, this kind of Rube Goldberg contraption made of legacy systems, and it's all quite confusing and sometimes not rational. The corollary impact for us on the manufacturer side is that lawsuits are out of control. We have, I think, 4 or 5 members on our board right now, on CEA's board, who are currently engaged major IP litigation. Some of these are small companies, and again, these companies are on our board. They're entirely legitimate. They're entrepreneurs. They're not pirates. They're not doing bad things. You got XM, of course. You got Google. You got folks like Load and Go. You got Kaleidoscape. You've got the Cablevision case, which for anybody in the room who has a TiVo and likes it and likes TiVoing like Sopranos on a Sunday night, you may want to look at, because this could potentially impact you. And with the statutory damages, not only do you have licensing disputes, but you quickly at $150,000 per infringement. XM being the poster boy for this. We have 2 million songs in the library times $150,000 per infringement. You quickly get up to these Dr. Evil type numbers where I'm suing you for $1 billion. And I mean, it's funny unless you're a small company.
Or what you're paying Howard Stern. It's
that's fine. So maybe if you're XM or Apple or Intel or whatever, you say bring it on. We can handle this. If you're a small company or a venture capitalist, you're kind of out of luck. And I've talked to members of ours who are thinking about bringing out new products that are, again, entirely legitimate, but it's a questionable, very hazy area of law. And the potential damages are such they don't want to do it. And that is a real issue for innovation, because you're also talking about a time when you can go over to India and you can go over to China and you can put forward your innovation and do quite well. So this is not just about our industry. There's a big competitiveness aspect to this as well.
Here's a question. I'll put this to Julie, because you know a lot about IP generally. But how is that different from somebody who wants to bring a prescription drug to market and has to check all the patents? There's other corollaries where people have to do the due diligence in terms of what they can and can't do. Is the issue that copyright law isn't settled on some of these issues, like the Viacom YouTube case, or is it just a lack of due diligence?
No, it's a gray area problem, and actually I think the pharma people would tell you they have the exact same problem, but I'm not one of them, so I can't answer that question. Instead, I want to just take the liberty of completely changing the subject back to Europe for a second. So an interesting thing about Europe is in some way the system is more rationalized because they don't have this rigid split between distribution and performance in terms of what the collectives can do. And I talked about how when you have a streamlined system like that, then you would want to give more thought to the opposite side of the coin and to formalizing consumer rights. And in fact, they have a long tradition of having done that there, right? So they have a long tradition of having in domestic laws rights for personal use copying and other kinds of things, as well as a long and much more robust tradition of consumer protection law than we have in this country, which addresses sometimes the substantive terms of what you can require in these license agreements. That is in some danger, though, of being swept to one side by the treaty structure, what's called the three-step test of TRIPS, which you really don't want me to get into, but the thrust of it is that anything that interferes with so-called legitimate exploitation of the work to too great a degree could potentially have to be cast to one side. And so they're confronting a similar problem to what we're confronting, but coming to it via a different route, I think.
Right, but by the same token, they don't really have a robust theory of fair use like we do, and in some countries you also have theories of moral rights. It's important. It's
right. So it's different.
It's different, and I wonder what is, depending upon where you sit. I wonder actually where you rate things in terms of being pro-artist, pro-licensee, whatever the case may be. I mean, it's almost impossible to answer that question, but...
Well, I think a product has to be successful in all major developed country markets, so it's a race to the bottom. So in that sense, it may not matter that much either.
Yeah.
I would just say I view that as just the reality that because essentially creative content that's been subject to copyright law for so long is now so prevalent and pervasive throughout society and so important to people, much more important, I think, than it's been in a long time, that we're finding out that copyright law can't answer all the questions that need to be answered about how people interact with their content, whether they be consumers or other users. And what's happening is, in Europe, as Julie pointed out, I mean, people are turning to consumer protection law, and here we turn to FCC for broadcast flag regulation, other areas of the law to try to help answer these questions. And definitely people self-interested on both sides, sort of pushing the envelope. The problem is that essentially that the copyright law was designed for a relatively narrow set of questions in the past. It's now being forced to answer a much broader set of questions and straining under that pressure, I think, a little bit. And I think that's a problem. And when you asked who would want to defend copyright, I'm not sure I want to, especially in the music industry, want to defend copyright law right now because it's a little bit Byzantine. But I do think there is a need for a defense of some form of exclusive rights or property-like right means of financing music and the creation of music. While obviously other business models are going to be tried, and there's no reason to stop those experiments, whether it be through using it as promotion for tours or selling other products or other things. I still think there's a real need, and it's generally been a very good engine of creativity and supporting of artists, exclusive rights, where you can actually, force the consumer to pay you up front for your music, whether it be product on a CD or a download or something. That system should still be prevalent and should still be an option for particular artists, especially individual artists who don't want to be associated with a particular larger label or some other larger entity that might help them monetize in those other ways. So now, whether or not our copyright law right now helps that is a big open question, and maybe we need some changes to that. But I think at least that concept should be defended.
Can I just say something very important? From the BMI perspective, it's all about the song, and it's about being paid for the song, because song generates great music, and the great songs have created great American music. And I say this because the copyright law has worked in this country because our music is revered throughout the world. And without this copyright law, it wouldn't be there. So there's something great about the copyright law in the U.S. at this point. It has worked up to now. Do we need to make some changes? Of course. But like anything, we're very good at finding ways to do this. We just have to sit down and do it. But the music is the essence of all of us here. And without great music and great songs and people getting paid for it, we have nothing. So the copyright law works from us, and it works for us.
I'd like to open it up to questions. Did you have a question?
No.
Oh.
Just point.
Who has a question? Nobody had. We were so good that no. There you go. We have a question back here.
Hi. Most of the panel focuses on performance. I'm somebody who has a small label. I'm also a publisher. Mine is on the delivery, which is, we used to be mechanical, now it's turned into digital royalty. And the copyright law has been, I'm split on this because I'm working both sides. The upfront cost of a mechanical or digital royalty has been on a continually stepped up basis every few years. It bumps up. In most cases, if you're a small indie, you have to pay that, however many you're pressing up front. So it's all upfront costs to pay a mechanical or digital royalty.
For a cover recording.
I'm sorry?
For cover recording?
For cover. Okay. For cover material. That's the delivery. Is there a point of no return where, now we're at almost 10 cents per copy per song sold? The amount we can sell it for has never gone up. It's either stayed the same or, in the case of digital, has come down. And the pressure is always on a downward selling point, but the cost of doing it is on a continual upfront or a continual rise. Is there a point of no return that we're going to reach where all of a sudden you can't do any cover material because all of a sudden it just became too expensive to do?
Well, this is goes directly to a lot of the issues that are being raised in the rate proceeding for the mechanical rates. And one of the things that the record companies have proposed is moving to a percentage royalty rate. Right now, you're right. You have a cents rate, and the trajectory has been upward while prices and sales have come down, and therefore, as a percentage, the costs for mechanicals have gone up significantly. Everywhere else in the world, in Europe, where I have similar systems, you have a percentage rate. And the percentage, accounts for that and enables people to share in the ups and the downs that take place over the course of many years. And we think that's a more appropriate system.
Fred, counter argument?
I don't deal with mechanical, and I don't delivery, but I'm asked to answer this question. Wayne, I don't really know. You might be on point there. I'm not sure.
Nobody else wants to jump in? Do we have anybody else? Oh, please. Oh, absolutely. We'll get to you next. I'm sorry. Tim Oliphant, ladies and gentlemen.
Thanks, Walter. I have a quick question about the house that you were describing. My question is, it seems like in the, online, in the internet world, that location is changing. Take YouTube, for example, with the embeddability of videos. So if we've got a database full of videos or a database full of audio, and someone takes that piece of audio and embeds it on their location, like their URL, who's responsible for the licensing? Because and this can open up a can of worms, because they're very podcast and XML feeds and RSS feeds. We're still experimenting with all this stuff. It's kind of really interesting and new. And you can take something like Yahoo Pipes, which is a very early stage beta version of collecting all this content and throwing them into different feeds that then can go everywhere over the internet. And then you've got folks like Google who are developing FeedSense, which is a version of their AdSense for XML feeds. So my question really boils down to, if everything's embeddable, if we have centralized databases that are hosting content, but the performance is all over the place, who's ultimately responsible for that?
Who wants to take this? This is like one of my favorite questions.
That would be you.
Yeah, why don't you take it?
I think about this all the time. I think it's fascinating stuff. Actually, you and I have had this conversation several times. I mean, I think it's a number of issues, and Julie talked earlier about gray areas. I mean, I think this is an issue that over the next couple of years is really going to become more and more important as to who actually is the licensee in those situations. And I would just say that the one person that I think is doing phenomenal work on this is John Palfrey at the Berkman Center at Harvard Law School. Is really the one guy who not only is really trying to address these issues, but also is doing a great job of looking out to other people who are attorneys and non-attorneys, trying to get a sense of what the consensus is in this issue. But I just think that this is one of these issues that we'll look back a couple of years from now and say this was the upcoming issue, and ultimately, I guess you go back to the source of where the thing is originating from. But with RSS feeds, I mean, that complicates it because it's no longer what the source is, it's who distributing it. So, I mean, I think that it's going to take a lot. I can't answer the question yet, and I've dedicated my summer and a few bottles of Cabernet Sauvignon to, a couple of other things, Irish coffee as well, to sort of mull this one out. But I think it's something worth thinking about. And I don't really think that we're at the point yet where we really have any scholarship of this other than some of the stuff coming out of the Berkman Center. But
I think it also depends a lot on the particular facts of the situation.
Oh, sure, absolutely.
Who's, how it's being monetized, where the revenues are coming, who's actually doing the distribution, et cetera. So,
and who's the creator? Because you may not know who the creator is.
Right. It's a hard question to answer, I think, in the abstract, but certainly an important one going forward.
Yeah. I mean, anyone? I'm sorry, you had a question?
Well, hi. I don't know if it's a question or a comment. I think it's probably mostly directed towards Michael. Sorry, I'm CEA again. But everybody's talked a lot about the businesses fighting over money and how different businesses are going to be getting money from each other. And every so often someone sort of mentions, and we really, really care about the artists getting paid. This isn't directed towards you. I think this is...
He says that a lot, yeah.
Well, the first Future Music Policy Summit, the new CEO of Napster said that a lot too, and I wasn't particularly convinced then either. But people don't really get down to business, and I'm a little skeptical at this point because I feel like for many decades, people have been saying, no, this is going to be really good for you. This is going to be really good for the musicians. I think you go back to major label contracts, sorry, but they dangle the carrot forever and say, no, trust us. You're going to give up some rights. You're going to do this, but it's going to be really good for you. Just wait for the innovation. It's going to help. And, there are always enough, like a handful enough people that it does work really well for, that they can keep dangling that carrot, but I don't really see it panning out overall. So this is coming from a now attorney for 2 months, but 10-year musician before that.
That's a great point. I guess I'd say a couple of things. I would say, first of all, if you look at this from a big-time historic perspective, I could either start with Gutenberg and running the printing press, or just start with like the player piano in 1900 or something. My point is that every one of these new technologies caused short-term disruptions, but ended up being good, both for consumers and for artists. Writers after the printing press were much better off, and musicians after the radio were much better off. And so I'm saying the overall trend line is a positive one. And then I think when it comes to digital technology in particular, again, I'm biased because look where I come from, but I do think that this technology has an opportunity to empower artists, especially artists coming outside the system, and in ways that have never been seen before. And the question is, how do you monetize this stuff, right? And I think we spent a lot of time. I'm sorry, just let me finish.
Yes, I know. Go ahead. Absolutely.
We spent a lot of time talking about what's fair use, and what should consumers be allowed to do, and what if they make 2 copies? What if they make 20 copies? Is that too much? And I guess the angle I would take is, accept the fact that to some extent the unauthorized downloading is going to be part of the picture for a long time, because some kid sets up a server.
I struggle with that. Sorry,
what?
I know I need to give it up, but I
no. But I'm like, but just let me finish. And some kid you knock Napster out of business, and some kid sets up a server in Chechnya, or Earth Station 9 is in the Jenin refugee camp in Palestine, and there's not a lot you can do about that. But if you can figure out a way to see what consumers want to do and then monetize that. There's a group out there that I know Network is working with, where their thing is they embed pop-up ads in music, and they seed the peer-to-peer services, and then you're the kid and you download the song, and an ad pops up and says, if you want like a free, clear, legal copy of the song, watch this ad. And then the kid watches the ad, and then artists and musicians get paid, and the kid gets the song, and nobody gets sued. And apparently this has been quite successful. I'm not saying this is the panacea, but I am saying that this is the kind of figure out what consumers want to do, figure out how to get money from that, and that in the end is what's going to make it work, as opposed to trying to legislate or litigate and change people's behavior, which won't work.
I understand what you're saying. I just think that people are generally asking the musicians to take the biggest risk on the front end to hope that it pans out for us. Oh, sorry. But later, I'd really like you to think of maybe 5 good reasons why your little XM recorder over there might not be like taping from the radio 5 years ago. It's my least favorite argument in the world.
No, it's fine. But for all the but for all the bad things you think this device may do, I would ask you to think about the good things it does, and the artists who would never get played on Clear Channel, who consumers can listen to and be exposed to through this. So I think every new technology has the costs and benefits, but I think the upsides are significant too.
There may be great things about it. I'm just saying that taping from the radio doesn't work.
Let me see if I can do this, though. I mean, I'll be dramatic, but I mean, I think you have to think in terms of, and I'm sure Julie would agree with me on this, but I think I like to look at things. You have sea changes, and you have events that are profound, and it may be something as recent as the Napster litigation. It could be, things that happened in the past. But I mean, I always think about Stephen Foster. Does everyone know who Stephen Foster is?
He died corporal.
Camptown Lady, Oh Susanna, and all those songs. But I mean, this guy died, in a Fleabag hotel in the Bowery, and he probably was the most important songwriter in American history. I mean, wrote songs that are still performed today, especially by children in the third grade, not to be sarcastic, but I mean, probably the guy who single-handedly, made popular music what it is in the United States in the 19th century. And, he didn't have the benefit, if I'm wrong, Julie, jump in, but his time preceded when musical compositions were copyrightable. He preceded the time of public performance rights. He preceded the time of when ASCAP was first formed and BMI came along. But the point is that, a sea change occurred so this guy could eventually make a living because they made musical works copyrightable. And then the performance right came along. So those events occurred, but before that, songwriters couldn't make dime one. I mean, and so, sometimes it's sea change events that have the biggest things, but there are actual moments in history where things happen that do benefit artists in the long haul, I hope.
So you may die a pauper, but your grandchildren will be just fine.
I'd say I would for a permanent copyright.
We went through that. We went through that in the 18th century, and that's side lost.
And there is that pesky Constitution. We can
That's true. Yeah. Anybody else Anybody want to jump in? Oh, there you go.
Yeah, I have a question for Michael. If you had to choose between simplicity and cost in licensing music for your members' products and services, which would you pick and why?
Great question.
Yeah, I mean, that is a great question. I don't accept the choice, and it's got to be
both of them.
No, I mean, for it to work, it's got to be both. It's got to be. I mean, obviously we're in a market, so the cost has got to make sense, and it's got to be simple. And that same thing extends not just for our members, but for consumers as well. I mean, it's got to be a simple, friction-free, hassle-free process at a cost that people find reasonable. Thankfully though, you can do it. You can. Most consumers will respond to that, and they don't. Who was talking about people who have more money than time and more time than money, and that dichotomy. The 18-year-old kid with no money in his college dorm room with endless amounts of free time and a T1 line, maybe that particular person is not a hot prospect. I think for the vast majority of consumers, they would be willing to pay for what they consider to be a good deal. It's the whole thing, the whole we can't compete with free and the game's over that doesn't make sense either. People compete with free successfully all the time, and they come up with a business model that gives an extra benefit that consumers find worthwhile.
Jewel, what is Microsoft? What would Microsoft's answer to that be?
Go ahead.
Well, I think the question of simplicity is a question of cost. I mean, it's a transactional cost question in the sense if it's not simple to do, that increases your cost, and then there's the cost of the royalty. And like most things, I mean, as I sort of started out, we would like the system to be as simple as possible and as cost effective as possible, recognizing that some royalties have to be paid, but you want to be able to get the licenses, especially for the types of services that consumers are demanding. And they're demanding a world that's not just doing one-off deals with music publishers to make records to sit in bins at Tower Record. That's gone. The world
is Tower Records.
Right, exactly right. And it was actually, that's a good point. I was at the Future Music conference in 2002, I think, where somebody from an independent record store up in Boston basically said in 5 years we won't have retail record outlets, and he was basically right. I mean, and it was pretty clear to him because he at the same point he said he made more money on selling Pokemon cards than he did selling CDs back in 2002, and so he could see that trend going. And I just think, again, I think the question is how do you I sympathize with Michael on the point that you can't really separate. There isn't really a dichotomy there. It's costs of both nature in terms of transaction costs and the royalty costs. And you want the system to work. And I think from our individual businesses perspective, like Zune or MSN, obviously they're looking at it mostly from the typical music user end, which is they want the lowest possible cost they can negotiate by getting and staying legal and serving their consumers. But from the whole company perspective, Microsoft, and this is a lot of what I do these days, is to try to think that there's sort of intangible general benefits that we get if we make the copyright system work, because we are, in other businesses, very much invested in the copyright system for our software and other businesses. So it's really important to us that whether or not we get a few cents off the royalties that we're paying on Zune downloads or something. It's really important that the whole system work and that people stop looking at copyright law as this impediment to the things that they really want. And that's a big reason why Microsoft is a supporter of orphan works legislation and other things that kind of can help release the tension and pressure that's on the copyright system. And it's also important, I think, going back to the other question, I really do think we need some system that promotes sort of an entrepreneurial artist creator, someone who does take the risk up front, just like those technology companies that use venture capital funds. That's extremely risky business, but they do get property rights in forms of capital stock in their business that if it does hit big, they make lots and lots of money. If an artist wants to take that very risky route, there needs to be some sort of system that is mostly like a property rights system that is involved with exclusive rights that actually does force people to say no and prevent people from doing things on occasion. That kind of system does need to be at least present and available for artists and for all creators, in my view. There may be other systems that help compensate them, but I think that sort of risk capital entrepreneurial system, which would depend on a general concept of copyright, is critical and should not be abandoned.
One last question, anyone? Okay, well, you're the closest, so. I'm sorry? Oh, I can't even see. I'm blinded by the light here.
Patricia.
I'm like Warren Beatty and Mickey One here. I'm ready to get the obscure reference.
I don't want to sound really wacky, and I don't want to sound like a Luddite, but I'm not anti-technology, not in the slightest bit. But to Michael's point in the exchange that we had a little earlier, I think one thing we have to keep in mind is that things do tend to be a little bit complicated, and I don't think it's sensible to think that the march of technology is always forward, and everything is always progress and ultimately is going to be good. The life tends to be just a little bit more complicated than that. So I'm thinking about recorded music and how the rise of recorded music created lots of new and wonderful things. It was a whole new art form. It spread music around in a great way. It made new kinds of opportunities. But it also, in fact, had the result of changing very drastically what the universe of live performing music was for real musicians all across this country, and reduced the number of people who could make a full-time living really from playing live music to real live people in their communities. And I'm not saying recorded music is bad, far from it, but the effects of technology can be really complicated. And I'd like to just sort of go back to where we were with the opening speaker this morning, who kind of concluded talking about government policy sort of beyond technology and beyond intellectual property. We said we need to find ways to support more live music in our communities and spread the benefits of government support beyond classical and jazz to other forms of music, and maybe go even beyond that a little bit, because I'm not just here talking about live music, but say we need to be thinking about policy that is pro-artist policy, pro-creator and performer policy, so that we can make it possible in our country for artist entrepreneurs and creative people to make a living, and be thinking not just about the business trickle down to performers and ways to make that happen, but really to support our creators, as a general matter. It's just got to be part of our mindset.
Yeah, ma'am, I agree.
I think you're absolutely right, and I don't think that you will get those proposals from, with all respect, the lobbyists represented at this table. Let's talk about Leadism, right? Leadism was not an objection to technology. It was an objection to a particular political economy that formed around industrial technology that treated workers in a particular way. The objection that musicians do not get paid enough is an objection to the political economy of the music industry, which produces, a world in which every music industry lobbyist at this table makes more in a year than a working musician would make in 10. It's hard to see how permanent copyright is the answer to that problem. You're absolutely right. You're absolutely right.
I have to just, sorry. But you're speaking as a professor of law about permanent copyright not benefiting artists and creators.
No, I said it's not an answer to the problem that she raised. You'll get a tiny bit of a revenue stream that lasts for longer. It'll still be a tiny bit.
I object to being called a music industry lobbyist. Yeah. I'd rather be called a monopolist.
Yeah, and I used to be a musician, so I really take offense to that.
See, I started a fist fight right at the end, but I stand by what I said.
Why don't you were in the middle of a thought there, Julie, so why don't you just finish that?
No, I'm done.
I was ready to lead everybody storming out of the room after those remarks.
Well, Walter, if you want to lead, we can get storming to the cocktail party.
That sounds
so what we want to do is say thank you first to the panel, to Walter, and thank you to all the panelists. On behalf of Future Music, we want to thank the sponsors of today's event. We couldn't do these events without the sponsors. We really appreciate all their help and support. I want to help, obviously thank ACS for being, really one of the best partners we've ever had in doing one of these events. Obviously, Kristen and Justin and Chai and the rest of the Future Music staff.